So I'm very glad that we're all here assembled in order to discuss this very intriguing topic when it comes to non-state actors. We have excellent presentations that are going to be put before us now in order to be able to actually instigate a wider discussion. As more people are rushing here in the room, that's why I don't introduce myself yet. But as I said, we are starting. And in essence, you heard also before, my name is Dr. Solomon, and I am a lecturer in the BIICL School of Law at Brunel University, London, a co-convener of the International Law Section in the Society of Legal Scholars. And I'm very glad because this panel has actually a variety, and I think this will actually instigate the discussions, a variety of speakers, geographical variety, gender variety, and a variety of topics in the sense that we are going to speak from the outer space to the seabed, meaning going from high to low. And with no further delays, we are going to have the speakers according to the order that they appear in the program of the workshop. The first speaker is Kushag Bakshi. If I make any mistakes in the names, always you can correct me. And Kushag is a SJD candidate, which is equivalent of a PhD candidate in the University of Michigan, United States. And he is writing about many things, if I'm not wrong, about all constitutional theory, about the Indian constitution there. But today he's going to speak about the Artemis Accords and the outer space. Before we continue, I give the floor to Kushak to say just that each one is going to present. We're going to have each individual presentation. In the end, the speakers can actually engage into this triangular dialogue for about another 10 minutes before also the rest, all of us, all the participants, can actually engage into the dialogue on the themes that we're going to speak about. So all the final comments and questions are going to be presented in the end of the three presentations. So, Kushag, the floor is yours.
Thank you very much, Solon. Sorry, and good afternoon, everyone. As Solon said, I'm not an expert in international law, so if I, falter here, bear with me. I'm going to try my best. Right. So my paper is about the Artemis Accords and the concept of sovereignty and property in outer space. So to frame it, the key document, which is globally accepted, which set up the field of international space law, is the Outer Space Treaty. And the Outer Space Treaty, I'm not going to try and regurgitate the whole thing here, but the key elements of the Outer Space Treaty I kind of want us all to keep in mind is that first, it says space is the province of all mankind. It also prohibits any claims of national sovereignty through use, occupation, or appropriation of space. That principle is also it exists in customary international law. There's a bunch of UNGA resolutions, it's 1721, 1967, so on and so forth, which prohibit appropriation of space resources. And finally, it also states that states are responsible for non-governmental actors and their activities in space, in outer space generally. So in my paper, I draw two principles which I don't think I can regurgitate here, but I look at the drafting history and how Brazil had an intervention or India had an intervention or what the US and USSR negotiations were about. And there are two basic principles I get out of the Outer Space Treaty. The first is the equality of all nations in terms of access to outer space. And the second is equity within all nations in terms of benefit sharing from any resources that are gathered from outer space, whether that's scientific data or actual material benefits. Those are the two principles that are enshrined in the treaty. There is no enforcement mechanism, as I suppose is true of most international law, but those are the two principles that you can gather from the Outer Space Treaty. So that's the background of the legal framework we're operating under. The second thing I want to touch about is how property and sovereignty function simultaneously and together and are based on the notion of exclusion. So sovereignty, there's what Lauterpacht said about sovereignty and how he constructed it as essentially exclusion. But I think the strongest definition of it comes in the Island of Palmas case, where Judge Huber essentially said that sovereignty functions to the exclusion of the control of any other nation. So if you can establish as a nation control over a particular area to the exclusion of any other, then you can establish that you have sovereignty in that region. And property, to my mind, also, although there is no international accord governing property, functions in much the same way. So Lockean labor theory, which is the sort of foundation of Western conceptions of property, at least, again, functions on the idea of it is a common space for everybody until you put in a particular amount of effort, and then you can derive value from it to the exclusion of everybody else. So what I'm trying to essentially say over there is that property and sovereignty both function on an exclusionary basis. And there is no international framework for recognizing property claims outside of a national framework. So property necessarily falls under sovereignty in international law. So it's only after a state can establish a sovereign claim to a particular region can they then enforce property claims by individuals or citizens within that region. So that's the hierarchy I see in property following from sovereignty. So those are the two founding blocks. And that being said, the real thing I want to sort of investigate through this paper is how the Artemis Accords would actually function. And so I'm going to give a little bit of context. So the Artemis Accords are considered the most revolutionary sort of change in international space law in the recent times. But I think that's kind of a false narrative. I think they're just an extension of US policy. And if you look at it that way, it kind of becomes really clear. So in 2015, the US passed the Space Resources Act, where they allowed US citizens to possess, own, transport, use, and sell abiotic asteroid resources obtained in situ. Which essentially is exactly what the Artemis Accords do as well. In 2016, at the Vienna meeting of the UN COPUS, a lot of third world states raised a lot of concerns about the allowance of private individuals to extract resources, but that didn't lead to too much. Because in 2017, Luxembourg, in 2019, the UAE, and in 2021, Japan all passed, relatively speaking, similar laws. And I think the sort of clearest explanation comes in a 2020 US executive order, where the president explicitly rejected the construction of outer space as a global commons, which is kind of the theory that underlies the Outer Space Treaty, and certainly the Moon Agreement, although the Moon Agreement is 17 countries have signed it, 33 countries have signed the Artemis Accord. So I guess you can't put too much weight on the Moon Agreement. But in 2020, the US president explicitly rejected the construction of space as global commons. So if that's the framework under which the US has been operating in foreign policy, then how do we understand the Artemis Accords? So in large parts, the Artemis Accords do kind of restate already established space law. They say it should be peaceful and you should share scientific data and so on and so forth. But I think the three major changes come about in Articles 9, 10, and 11 of the Artemis Accord. So Section 9 is concerned with preserving the outer space heritage, which they define as historic landing sites or expeditions which robots and man have made in outer space. Best way to read it, I think, is that it's aimed at the preservation of the Apollo 11 landing sites. Section 10 explicitly allows for the extraction and utilization, including recovery, of abiotic resources from outer space by private individuals. However, they do explicitly state that that does not constitute a claim of national appropriation. And in a minute, I'll tell you why that makes no sense. And then Section 11, which is perhaps the most detailed section in the Artemis Accords, focuses on what they call deconflictations. And they call it the establishment of safety zones where countries or private individuals operating under the aegis of countries, because that's required by the Outer Space Treaty, will be able to operate in safety without the interference of other nations in those regions. So the Artemis Accords haven't actually been operationalized, although everybody who wants to join NASA's program has to sign into the Artemis Accords. And as of now, I think there are 33 countries who have signed on to it. But I guess what I'm trying to figure out is how would this operationalization actually work? So if Section 9 is to be read literally, the way I see it, the landing zone of Apollo 11 will be declared an exclusive zone, which no other country will have access to, which again functions on a space of exclusion. The safety zones, again, will effectively become exclusive economic zones, where they'll be set up such that no other country is able to access them, and only private individuals and nations will be allowed to access them, with others having to ask for permission to even enter those zones, which in my mind just reads as an exclusive economic zone, because those private companies will be granted exclusive access to that zone and the resources that are guaranteed from there. So if you tie all of this together, the way I see it is that sovereignty is premised on exclusion. Property is premised on exclusion. The Artemis Accords guarantee property through sovereignty, again premised on exclusion, because they allow states to essentially set up zones, which, while they may not call it a claim of sovereignty, are exclusive and are only allowing citizens of that state to take property from, which will then be governed by the national laws of that state, which in my mind just reads as a claim of sovereignty. So I think, like, on that sense, the Artemis Accords just strike me as a violation of the fundamental principles of international space law and the Outer Space Treaty. There's a couple of arguments I've heard when I've discussed this before, which I want to head off. So there's one which says that, no, why don't you look at fishing in in the high seas, where it's allowed for commercial exploitation? To which my response has always been that fishing is not exclusive. Like, anybody is allowed into those zones and allowed to fish. It's only after they've been collected do the fish become the exclusive property of that person. That's not the case here because of the exclusive zones that are being set up. Nobody's even allowed to access them. So I don't think that analogy holds. The other one I've heard from John Sprankling specifically, I don't know if this is common, but Sprankling sort of argues that you shouldn't look at them as property rights, but as usufruct rights, where you get temporary claims of property. And he tries to compare it to the ITU, which I think is a bit of a stretch. But my point is that if you look at Article 6 of the Outer Space Treaty, it explicitly makes states responsible for the actions of the private individual. So I don't really see how this can be usufruct, because you're only acting under the authority of your domestic law paradigm. So it's not some international claim to usufruct that you're functioning under. You are functioning under property rights guaranteed by your domestic paradigm. And my response to this has always been, what if China or Russia, or India for that matter, which have a lot of state-owned entities, sign on? So what if India then sets up an exclusive zone, which is a state-owned entity? To my mind, that collapses the distinction between public and private almost instantly, and it just then becomes a national claim of sovereignty. So I'm not entirely sure that I'm convinced by those arguments. But and that's the sort of first three sections of my paper. So if you're with me and I've convinced you that it is in fact a claim of sovereignty and a claim of property, then I want to tell you why this is essentially colonialism rebirth. So Alan Wasser has for a long time been arguing that the right to claim newly settled property provides the economic incentive for human expansion. Many other sources which talk about this describe resource mining as extraction or exploitation or even the gold rush. NASA in itself has an exclusive page dedicated to space colonization. And I want to draw you a parallel. Think about a private company, which is authorized by a special charter of authority by a sovereign state, which sets off to explore what is otherwise called uncharted territory. Eventually, it gathers some land, which it owns, which is then transferred by a sovereign act to the sovereign state itself. To me, if you compare those two parallels, you're essentially talking about colonialism, because this is a story of how the British captured India, or how the British captured the US, or South Africa, or many other countries that I could talk about. So to my mind, I think that the rhetoric that's being used and the process that's repeating is essentially just colonization, except this perhaps might be the first time that it's truly uncharted space, as far as we know it. And I kind of want to end with saying that, like, the development of international law is a development of colonialism. International law has developed as part of a colonial model, particularly focused on sovereignty. Space law has been one of the few paradigms where we've been able to resist that, because it started in the 1960s after colonialism had seen its heyday. But I think that this new sort of paradigm that's been set up shows how international law is still interacting with the aims of colonialism through the concepts of property and sovereignty in what is now called the final frontier. In 1963, the US conducted some high-altitude jet tests over the UK, which caused a public furore in the UK, and there was a debate in Parliament about it. And there's a question that Representative Matthew Foote asked over there to the Prime Minister, who at that point had no response to it. So he said, does the United States government think that they have the right to treat the universe as if it belonged to them, like some Latin American state? I think he was trying to be funny, mildly racist. But I guess my question then is, if the Artemis Accords are to be read as what the Global North is doing concertedly, then I would ask, does the Global North think it has the right to treat the universe as if it belongs to them, like some colonies? Thank you very much. Thank you for bearing with me. Look forward to your questions later. Thank you.
Thank you very much, Kushak, for this informative and interesting presentation. Many questions have been begotten. As I said, we're going to discuss them in a while after we hear also from the other two speakers, because Kushak, I think you made a good introduction also. As we said, both Jon and both Alberto are going to speak about space and the seabed respectively. So in essence, we're staying in the same thematic, but we're broadening now the discussion. And so Fiona will bring into the discussion the issue of space pirates. We know about pirates in the sea. And now, Fiona, the floor is yours. And welcome, Fiona, once again. And we're ready to hear your presentation.
Hi there. I'm just going to upload some slides.
Of course, yes.
Are they coming up?
Now, yes, everything is fine now.
Hang on. Bear with. Do we have slides? Hello?
Yes, we can see the slides and you can
Okay,
move them
fantastic.
also. That's the important thing. Sometimes they're being stuck if it can happen, but you can move them also.
Okay, brilliant. Thank you. Okay, right. Following on, still in the zone of space. Good afternoon. My name's Fiona Naismith, and I'm introducing the proposition of piracy jure gentium in outer space. Since 1967, all human activity in outer space has fallen within the purview of international law and predominantly the Outer Space Treaty regime, and as noted by Kushag, founded upon principles of non-appropriation, benefit sharing, and peaceful purposes. More recently, however, private actors incentivized by the promise of rich pickings and free rein have kick-started a private space sector boom. As observed by Lyland Larson, the problem facing the international space community is the disciplining of entrepreneurial enthusiasm by cogent law. So in this regard, Article 6 of the Outer Space Treaty obliges states to authorize and continuously supervise its national activities in outer space. However, due to a patchwork implementation of national licensing schemes, this has created a regulatory gap, leaving non-state actors considerable discretion in their uses of outer space. This risks irreversible and damaging harms to the use of outer space and the environment of outer space. So this paper aims to show that the doctrine of piracy jure gentium is a living instrument capable of adapting to meet the needs of a technologically advanced, globalized society operating in outer space. And moreover, it enables states to respond to threats in outer space where the conduct is beyond the control of the state, which would otherwise be held responsible. Okay, so the contemporary model of piracy jure gentium is embodied, albeit not exclusively, within the UN Convention of the Law of the Seas, hereafter UNCLOS. Under Article 101A2, piracy jure gentium consists of three elements. First, any illegal act or violence or detention or depredation. Secondly, the victim vessel, persons or property must be situated in a place outside the jurisdiction of any state. This would include outer space. Moreover, unlike acts committed upon the high seas, Article 101A2 does not contain a two-ship requirement, and this will allow for a definition of piratical acts, which includes activities such as hijack. Thirdly, piratical acts must be committed for private ends. It is also an offence to incite or facilitate an act of piracy, such as dry land piracy, and in all circumstances, preparatory or attempted acts of piracy are sufficient. However, UNCLOS offers us no definition as to the meaning of piracy jure gentium, and neither does it of itself criminalize piracy, which means that the piracy regime is designed to complement national schemes. This means that in order to define piracy jure gentium, it's necessary to piece together the fragments of differing national approaches to develop a normative understanding of a pirate. So this paper comprises some initial findings on the identification of piratical acts in outer space, and specifically at the technological demands of outer space. So turning first to robbery of a vessel. In 2014, 2 NOAA satellites were brought to a standstill for 48 hours when they were cyber attacked. To put this into an economic context, the London Economics calculated that for a global satellite system blackout for a period of 5 days would cost the UK economy £5.2 billion. More importantly, The robbery of a satellite risks the full-scale destruction of a satellite by either enforcing an attack or a collision with another space asset. The piratical act of robbery of a vessel comprises the taking of masterful possession of the vessel to the exclusion of those properly in charge of it, and thereafter appropriation of that vessel for one's own use. Acts of appropriation can include robbing the keys, stealing or destroying the vessel's communications equipment, and redirecting the vessel's navigation. So it's easy to see that these equate quite readily to cyber activities, such as the robbery of access codes. Robbery of a vessel further requires a causal connection between the menace and the taking of possession. So whilst invasion is in itself an act of violence, commercial insurers demand a higher standard before covering such loss. So for example, in the marine insurance case, Andreas Limos, the court found a nexus may be inferred between a furtive use of force and the fact that victims had taken reasonable steps to protect themselves from such attacks. It thus follows that where a spacefarer adheres to and maintains cybersecurity standards, a subsequent cyber attack would amount to a piratical act. It's well established that acts of war done without the authority of a state are piracy. For example, in 2022, the hacktivist collective Anonymous declared cyber war on Russia and claimed attacks disabling Roscosmos access to its spy satellites. Denying the claims, Dmitry Rogozin of Roscosmos cautioned that disabling the satellite group of any country is generally a reason to go to war. In reality, the term cyber warfare properly refers to a small subset of cyber attacks. Silver asserts that a cyber attack can only justify self-defense in circumstances incurring loss of life or substantial property damage. Thus, low-level cyber attacks such as espionage or criminal activity will be excluded from acts of war. So to illustrate, in 2022, security researcher Carl Kosher used a radio transceiver costing $300 to revive a decommissioned Anik FIR satellite and directed it to broadcast movies across North America. So whilst this is a menace, it is not an act of war. By contrast, if the same technology were used to target the International Space Station and causing damage akin to the firing of a missile, this might be an act akin to an act of war. However, as noted by Anon2 or Anonymous, the Achilles heel of Anonymous is that anyone can claim to be a hacker of Anonymous. So where it's impossible to attribute responsibility for an act to a particular state, the doer of the offending act, whether a person or a vessel, are pirates jure gentium. Furthermore, under Article 105 and 107 UNCLOS, all nations are entitled to seize and dispose of not only pirates, but also pirate vessels. The definition of piracy is not, however, dependent upon acts of robbery or mastery. For example, an armed vessel requires the authority of a state behind them. So any armed vessel not so authorized is a pirate, even though no act of robbery has been committed by it. This is highly irrelevant in outer space, where dual-use technologies are the norm. For example, in 2022, China's SJ-21 satellite, complete with a robotic arm, was used as a space tug to tow a defunct navigation satellite into a graveyard orbit. However, as observed by the US Space Force, this debris removal exercise illustrates the potential dual-use capability of the SJ-21 to interact nefariously with other satellites. Similarly, in the case of the Ambrose Light concerning the siege of Cartagena, the court stated that the blockading of ports, which all nations are entitled to enter, are an attack upon the rights of all mankind and menace with destruction the lives and property of all who resist. To take a contemporary example, in 2022, the commercial company Viasat suffered a DOS attack, on a communications satellite, which resulted in a significant interference with German wind energy infrastructure. If this attack were a sustained one, this would constitute a piratical act. Further, in 1927, Romania, in its report on piracy to the League of Nations, declared that the sending of false signals or information by wireless to mislead ships in order to plunder the wreck should obviously be treated as piracy and severely punished accordingly. Similarly, in 2011, the spoofing of GPS coordinates of an unmanned Lockheed Martin Sentinel, which is subsequently captured after it was misdirected to land in Iran. It is thus submitted here that all such mischief falls within the definition of piracy jure gentium. The essence of piracy, however, lies in the requirement that the act is committed for private ends. This goes beyond mere pecuniary gain. As recognized in the case of raid piracy jure gentium, it's quite possible to attack for private ends, not with a desire for gain, but for vengeance or for anarchistic or other ends. Here, anarchy would refer to the likes of the illegalist Bono gang of the early 1900s, who, using cutting-edge technology, which was not then available to the police, such as automobiles and repeating rifles, committed bank robberies and donated the proceeds to the cause of wealth distribution. For Jules Bono, this was a question of principle and not profit. So this highlights that political ends are capable of being inherently private. Cyberspace offers the contemporary anarchist an equally cutting-edge platform of expression, such as the Hacktivism Collective and Anonymous. An alternative school of thought excludes all politically or ideologically motivated acts. Traditionally, this is founded upon the theory of selective targeting by unrecognized revolutionaries who may be punished by the offended state as they see fit. However, the expansion of this approach in certain jurisdictions to include all politically motivated acts has created difficulty in cases such as terrorism. For example, in the Sea Shepherd, the Ninth Circuit observed that the fact that perpetrators believe themselves to be serving the public good does not render their ends public. However, it's submitted here that proving the non-existence of public ends does not of itself equate to proving the existence of private ends. It's not a binary choice. Rather, the imperative properly lies in the defining of private ends as a standalone concept, regardless of any competing interests or bolt-on philanthropic motivations. In the case of the corporate actor, however, the focus upon pecuniary gain constitutes a private end. Thus, in the event that a commercial satellite engages in acts akin to acts of war, such as providing battlefield communications for private ends, this is prima facie a piratical act. And lastly, the test of piracy further requires that there is an absence of a competent authority over the conduct complained of. Under Article 6 of the Outer Space Treaty, states are internationally responsible for national activities in outer space. Applying a strict jurisdictional test, national activities include all space activities conducted from within the territorial or quasi-territorial jurisdiction of the state at issue. Under Article 8, jurisdiction and control over a space object lies with the state of registry as determined under the Registration Convention. However, a strict jurisdictional test does not account for circumstances falling outside of the responsible state's control. So, to review the piratical acts we've considered so far, in the case of Starlink's near collision with the Tiangong space station, Starlink was operating an ordinary commercial satellite in accordance with US licensing laws. The collision threat was not an event outside the knowledge or control of the registry state, namely the US, but rather was a foreseeable act occurring within the course of an authorized commercial activity. This collision mishap thus falls outside the definition of piracy jure gentium. In the case of the cyber attacks upon the NOAA weather forecasting satellites, the robbery of the control over these satellites is a piratical act. The entry point for the attack was a ground station. The entry point for the attack was a ground station web application. Thus, the pirates were situated on dry land and within the territorial jurisdiction of the state. However, a piratical act crystallizes into the crime of piracy at the spatial point of the victim and not the attacker. Moreover, once the hackers took control of the object, the NOAA satellite of itself became a pirate vessel, over which no sovereign state had competent authority. Thus, in the event of a sustained attack, which threatens the peace and security of outer space or other users of space, a pirate satellite can thus be seized and disposed of by any state warship or other state authorized force exercising universal jurisdiction. Lastly, there have been numerous incidents where space objects have been hacked in order to repurpose the vessel for nefarious or aggressive objectives. In many of these cases, it is either impossible or undesirable for a state to be held responsible for the belligerent acts conducted by private groups for private ends. As such, it is submitted here that a coherent reading of the Outer Space Treaty, alongside the law of piracy jure gentium, shows that these types of acts do constitute acts of piracy. Thank you.
Very much indeed, Fiona, for this presentation. You open to different fields of law, to laws of war, to criminal law, and we're going to discuss, I think, afterwards all these issues. As now Alberto is going to take the floor, Alberto Pecoraro, the lecturer in the University of Hull, who is going to take us now to the different environmental section of our planet, which is the sea, the seabed. Fiona made a bit of introduction speaking about UNCLOS, and Alberto, I think, will dive into the sea in order to unearth the pearls of the presentation. So, Alberto, the floor is yours.
Absolutely. Thank you very much. I am very glad to be here, and I am very glad to come just after the space lawyers. It's always interesting to hear what they say. And yeah, to continue talking a little bit about the common heritage of humankind after them. I'm going to share the screen right now. Just give me a moment to figure out how this works. Yes, am I sharing?
Yes, everything is fine, Alberto.
Right. Just give me a moment. Okay. All right. I hope you can see the presentation.
We can see, yes, everything is set.
Okay, perfect. So I'm going to talk to you a little bit about the common heritage of humankind and about deep sea mining more specifically. And probably everybody in the room knows that an UNCLOS designates deep seabed minerals and the international seabed as being the common heritage of humankind. And this basically means that no individual and no state may unilaterally appropriate deep seabed minerals and the international seabed. Instead, UNCLOS creates an international organization, the International Seabed Authority, which alone can attribute and grant mining rights over the international seabed. In addition, of course, the authority has a central role to play when it comes to the regulation of mining activities in the international seabed. So at the current stage, the authority has granted 31 exploration contracts to various private and public entities. It is currently working to finish the exploitation regulations and might very well receive the first application for an exploitation contract by the end of 2024. So, of course, the role of the authority is central. But this doesn't mean that states have absolutely no place in this system. On the contrary, their place is very important indeed. Firstly, no application for an international seabed authority contract will be possible unless it is supported by the state of nationality or of control of the prospective deep seabed miner. Additionally, the regulation on the exploration of deep seabed minerals say explicitly that even once a contract is granted by the authority, the deep seabed miner must retain the required sponsorship. Otherwise, there will be no contract. So all of this spells that even though states cannot grant mining rights over the seabed, nevertheless, no exploitation or exploration of deep seabed minerals can happen unless there is a decision made by a sponsoring state that this is desirable. And just like any decision by a public body, such a decision can be challenged by affected parties through judicial review. And indeed, there are many parties who would not be very happy of the decision by a state to sponsor the exploitation of the deep seabed. This, of course, includes environmental NGOs concerned by the environmental impacts of deep seabed mining, but it could also be other users of the same maritime space, like the submarine cables industry, or also the fishing industry, for example. And then the question here becomes, firstly, whether such kind of claims are contemplated by UNCLOS and by international law. And secondly, whether this kind of claims would be possible or successful under rules of national law. And so in this regard, I'm going to answer to these two questions one by one. And we can start with the one about international law. What does international law have to say about the dispute settlement function of national courts in sponsoring states? And it turns out that UNCLOS does have something to say, even if it doesn't deal, of course, with all the detailed questions. So you will know very well, probably you're very familiar with the advisory opinion of the seabed dispute chamber on deep seabed mining. But basically, UNCLOS gives sponsorship under UNCLOS has very important legal consequences. You have under Article 139 of UNCLOS a duty to ensure the respect by contractors of the applicable legal framework. And while this duty is inherently flexible and evolving, nevertheless, the seabed dispute chamber has set some minimum criteria to be followed. You have underlined them here. They say it better than I would, and they include the application of the precautionary approach, the conduct of environmental impact assessments, and the availability of recourse for compensation in respect of damage. Additionally, UNCLOS in Article 21, Annex 3, recognizes that sponsoring states have an independent regulatory role from the authority, and that they may impose environmental requirements that are more stringent than those of the International Civil Authority. So you see here a very important regulatory and lawmaking function by sponsoring states. But then this doesn't tell us much about courts. Basically, on one hand, we should keep in mind that UNCLOS creates a complex, compulsory dispute settlement mechanism for deep seabed mining. This is in Article 187 of UNCLOS. But on the other hand, this very Byzantine and complex dispute settlement mechanism has some important gaps. It is, for example, not concerned with the interest or the claims of third persons against such regulators as the International Civil Authority or sponsoring states. But at the same time, on the other hand, UNCLOS does recognize that there are third persons who have legitimate interest which must be protected. And this is very clear in Article 235 that concerns the availability of recourse and relief in respect of damage caused by pollution. And the seabed dispute chamber in its advisory opinion had very much in mind these questions when it talked about the duty to afford venues and remedies for compensation of environmental damage. But then this brings me to another question of whether Article 235 is limited to claims for compensation after the damage occurred, or whether instead it is also about remedies that try to prevent the damage rather than just to compensate it, as for example, judicial review of government decisions. And of course, we cannot answer this question for sure, but I think that there are some elements that tell us that the answer should be affirmative. that Article 235 of UNCLOS is not just about compensation for other users of maritime spaces. And this is based on various considerations. The first is the broad wording of the provision itself, which speaks about compensation or other relief in respect of damages caused by pollution. So you have a wording that does not prima facie exclude other kinds of remedies beyond compensation, other kinds of judicial actions beyond claims for compensation. Additionally, you have the context provided by other provisions in UNCLOS, including Article 194, which speaks about the state's duty to take all measures necessary to prevent, reduce, and control pollution. And finally, also part of the normative context, you have the fact that states, under their due diligence duties under Article 159 of UNCLOS, must undertake environmental impact assessments. And you have a variety of authorities in human rights law in particular that tells us that in order to comply with international law, an environmental impact assessment must provide certain procedural guarantees to affected parties, including, for example, access to environmental information, public participation in environmental decision-making, and finally, access to justice. And this point has been underlined by numerous regional human rights courts, including the Inter-American Court of Human Rights in its advisory opinion on human rights and the environment, the European Court of Human Rights in Taksim versus Turkey, and also by the African Court of Human and People's Rights in the very famous SERAC versus Nigeria. So UNCLOS does tell us, possibly, that the courts of sponsoring states do have the power to hear claims for judicial review against the decision to sponsor exploitation activities in the deep seabed. But this doesn't provide any answer on many details, many aspects, very practical aspects relating to these sort of claims, such as, for example, who would be the competent judge, which would be the jurisdiction and admissibility criteria, and finally, how would a national court decide such a type of claims. And in this regard, we can only note that the national laws on deep seabed mining of various states give very different answers to these questions. For example, you have some laws, those of the Pacific Island states, that explicitly foresee the possibility of judicial review for decisions made under these laws on deep seabed mining. You have other legislations, such as those of the United Kingdom and of Belgium, on the other hand, that do not make any specific provision for disputes. Of course, this doesn't mean that there is no competent judge. It just means that we will have to find our answers in the general laws on the power of the judiciary in those countries. But you will see, or we can see, that those general legislations were not made with having in mind the specific, the very peculiar nature of deep seabed mining activities. One very good question is that of standing, of the presence of sufficient interest by NGOs to challenge decisions concerning activities that take place thousands of kilometers away from the territory of the sponsoring state. And in this regard, different legal systems respond in different ways to this question of the standing of NGOs. So traditionally, for example, the United Kingdom has been known to be very flexible when it comes to the interest or the sufficient interest of NGOs. The courts have considered that limiting the right of access to justice to people impacted by a state decision would make many state actions unreviewable and would not serve the principle of the rule of law. And consequently, they have allowed NGOs to bring claims for judicial review on two grounds: their representativity of people who were affected, maybe that is not our case when it comes to deep seabed mining, and secondly, and this is more important for us, the domain of expertise of those entities. Meaning that in cases where, for example, you had an important public interest issue and there was no other claimant in a better position to bring a claim for judicial review, then NGOs were afforded access to the English courts, even though they could not say they were directly affected or their members were directly affected by the outcome of a decision. And a very good example of this is the case of ex parte World Development Movement, a case heard in the 1990s, where the High Court held that it could exercise judicial review over the decision by the government to fund a controversial development project in Malaysia. So this shows you that something doesn't have to happen in written for an English court to affirm its power to exercise judicial review. This is Britain. In other countries, the situation is a bit different. In Belgium, for example, traditionally, it has been considered that judicial review will be possible only for parties that can justify a personal and direct interest, meaning that there is no actio popularis in Belgian law, and that Belgian courts were very hostile towards a judicial review claim based on the environment's interest or on the public interest. But this has gradually started to change under the influence of human rights law. We can talk about a very important case before the European Court of Human Rights, Leglantier versus Belgium, but also about the influence of the Aarhus Convention. So, for example, in the case of BIICL and others, in the case of, Gateau and others, the Council of State considered that an environmental NGO did have the interest required to contest a wind farm project in the other side of the country. And more importantly, in the case of Klimatzak, which is the Belgian equivalent of Urgenda, the Brussels court used or interpreted provisions on sufficient interest in light of the Aarhus Convention and the consecration by the Aarhus Convention of the special place of NGOs for the purposes of environmental justice. Hence, for the court, this NGO, Klimatzak, had the sufficient standing to challenge government policies concerning climate change, which is a very global and generalized issue in today's society. I will add a very last thing because I know that I'm running out of time. So we know that different systems deal with standing in different ways. That I think a plausible case can be made in both systems, English and Belgium, that NGOs would have such a standing in respect of deep seabed mining in the international seabed. But of course, this doesn't really tell us much about how a national court would decide such a claim on the merits. And in this respect, many variables will come into play. For example, whether the applicable law integrates international rules at all. Different laws do it in different ways. For example, the Belgian law only speaks about considering the precautionary approach in deep sea mining. The Cook Islands law, on the other hand, speaks about complying with the precautionary approach. And even though in the Cook Islands or in other jurisdictions where international norms are applied and integrated, well, it's not certain that national courts will necessarily follow the same interpretation and the same approaches of international courts. And a very good example, and then I will be silent, is a case, very recent case before the UK Privy Council, where basically the Privy Council held that the state, the Cook Islands, had no independent duty to carry out an environmental impact assessment once the responsible regional fisheries management organization decided that it was fine to expand fishing in the region. So basically, there's a lot of questions that need to be addressed when we talk about this kind of claims about deep sea mining and the role of national courts in deciding deep sea mining claims. And these questions are both questions of international and national law. With this, I know I went a bit above the required time, and I thank you for your attention.
Thank you very much indeed, Alberto, for this insightful presentation. Usually, procedure is boring, but you managed to make it interesting, and we thank you for this. And along these lines, we open now the discussion. As we said, first of all, we're going to have the first reactions of the other two speakers to each respective presentation. Before also, you, the members of the audience who are here with us, we're going to broaden the circle, and you can also raise your questions to the speakers. After, let's say, we hear the first questions that come from the other two. So let's focus first on Kusharuk's presentation, and to ask Fiona and Alberto if they have any questions regarding what Kusharuk told us about this new way of colonization, maybe in the moon. Because the truth is, I have something. Kusharuk, first of all, I found your presentation very fascinating. I have two questions, but I will, of course, utter now the first one. The first one, I think, is the easy one. The easy one relating to India. Colonization belonged to the global north traditionally, to the developed countries. India is a developing country, but India sends satellites to the moon. If we say that we have a new colonization in the moon, is this now, do we have also new culprits as subjects of colonization? Meaning also developing countries can be colonizers. And what are the implications of international law and for international relations? This is my question. If you want to address it, and then also Alberto has a question to make it maybe like this a more dynamic dialogue. So you can address this question, and then Alberto also will voice his.
Sure, no, I'm happy to do so. So yes, India sends satellites to the moon, but I don't know, India hasn't signed on to the Artemis Accords, to the best of my knowledge, and the satellites have been purely exploratory missions, and they've never really intended in any sense to be private resources. At the same time, I agree with the premise of your question. It's quite possible that that changes. It's quite possible that you would see China as a developing nation, which would then become a developed nation, and because they have state-owned enterprises, much like India does, any such attempts which they are inevitably going to join at some point of time, I feel like, yeah, I can see that frame being reversed. Like, I'm not necessarily sure that the frame has to remain so constant as to say colonization is only coming from the UK or the US. Sure, I think it can be broadened to include countries which have otherwise traditionally been colonized. But I suppose the frame I'm using is exclusion. If your activities are exclusionary activities, then I have a problem with them. If they're not exclusionary activities, which to the best of my knowledge, neither India nor China's activities have in any ways been linked towards property or exclusion, I don't necessarily have a problem with them as of now. But the premise is fair, yeah. I don't think it's a static sort of framing of who can be a colonizer and who can't.
You know,
Sure.
Kusharuk, this also augments the problem, because if the premise is fair and correct, the question is, and because we want create an international system that is just and fair, if states learn from their history, meaning would we expect colonized states to become colonizers? How normal is this? How worrying is this? If you want to comment on this.
I could, not in the context of space law. I mean, there's a fair claim to be made that India's position is Kashmir is a settler colonial position. And that's not a claim I would entirely disagree with either. So that's a fair claim to be made. I think normatively, the response to that has to be a sort of consultative, participative international law framing process. So like, take the Artemis Accords, for example, right? The US drafted them on their own, made it a precondition to anyone joining the Artemis program, and are essentially exclusively non-consultative accords which have been set up, which anybody who wants to access NASA's resources has to sign into. Now that, I think, is furthering the narrative of colonization. If on the other hand, it goes through the UN, so I'm not necessarily even opposed to property rights in outer space. I see the value of them. But I think if it goes through COPUS and it's a consultative process to the framing of any international law for that matter, then I think we're taking sufficient steps away from the binary of you're either colonial or non-colonial. I think if you continue to do things unilaterally, you're reinforcing that binary.
Also, Fiona wants to say something. Fiona, just to give maybe the speech to Alberto, and then we go to you. So, Alberto, yes. And then
Yes,
Fiona.
thank you. I have two questions. One simple, the other possibly a silly one. So bear with me. So the simple question is, You speak about Section 11 of the Artemis Accords about safety zones. I didn't really hear who can establish them. So is it a decision of the states, or is it a decision that private entities can make on their own? This is my first question. And the second question, you make a parallel, or a possible parallel with fisheries in the high seas, no? And I think you said that, well, in fisheries in the high seas, there is no such thing as exclusionary zone. However, I was thinking that there is such a thing as regional fisheries organizations, which do have a power under the UN Fish Stocks Agreement to exclude states that do not, or vessels flying flags of the states that do not comply with the criteria of those organizations. And I was wondering what you thought about using a structure similar to regional fishing management organization within the context of space activities. I mean, it sounds crazy, but who knows?
So,
No,
who's
sir.
curious? You can answer.
I can answer. Right. So the safety zones, it's actually kind of strangely phrased. So they're called, the entire section is called deconflictation of space activities. It's sort of phrased in a way as to make you think that what they're actually talking about is peace, but that's not what, in my mind, they're really talking about. So I'm going to read the specific section because I really don't have a clear answer to this. It makes no sense to my mind. The signatories intend to use their experience under the Accords to contribute to multilateral efforts to further develop international practices, criteria, rules applicable to the definition and determination of safety zones. So to my mind, the call is for the states to develop a new framework, which would then specify who can actually set up a safety zone and who can't. They later do talk about like the way the notification will be implemented and so on and so forth. And it doesn't really mention that private actors can themselves establish a safety zone. So to my mind, if it is to be implemented now, which I don't think it has been yet, then it would be that a state has to declare this a safety zone. And under the aegis of the state, any private actor could act because Section 10 allows them to have exclusive control over the use and appropriation. So if the private actor has exclusivity, it has to be guaranteed by the state. That's the way I read this currently. But again, these haven't actually been implemented. Like nobody's out there doing this just yet. So it'd be interesting to see how it plays out in fairness. On fisheries, again, let me also concede, I'm a comparative constitutional lawyer. I'm not actually an international lawyer. This is just, something I dip my pinky into. So I've studied a little bit of how regional fishery organizations work. And I think there is growing calls for generally to have a consultative body in space which regulates this, somewhat similar to the ITU, which regulates the bands, the orbits you can place your satellites into in space. And then there are calls for this to regulate activities in outer space. So I don't think it's necessarily a bad idea as such. The difference to my mind between the exclusion right now is that that organization excludes particular states from functioning, but it doesn't exclude and if you're a part of that organization, through that you can kind of each state has access to a particular zone. The sense I see right now is that the US can right now land on the moon and declare a particular area exclusive and nobody can enter it. Not even not even states who have signed the Artemis Accords can enter it. So I don't think this is even going in that direction. I think this is national, a claim of national sort of exclusive sovereignty, use, control, whatever it is you want to call it. But yeah, I think regional, a body is needed. I'm not sure what frame it'll come out in. The UN corpus hasn't really been active, and since the Moon Agreement sort of tanked, nothing has really come out of that in a conclusive way. So I'm not sure that it's actually going to happen, but it would be beneficial.
Thank you very much, Kushagra. Fiona, you had a question, or more maybe.
I did. It's more of a sort of general point, really, to both Alberto and Kushka. Really, that it's Article 1 of the Outer Space Treaty. One of the key principles is the benefit sharing principle, where the use one of my questions is, the current frameworks do not appear to take into account sufficiently the needs and development of developing countries. And how do these framework, how do we move this forward such that the developing nations have a greater voice in how these frameworks are developed? Because at the moment, it seems to be very unbalanced, and the dominant sort of spacefarers and those in seabed are dominating the resources, and there is no benefit sharing here as far as I can see. So I would ask them their thoughts generally on that point.
Thank you, Fiona. So Kushak, yes, and Alberto.
Right. So on the benefit sharing, I actually meant to speak about this in my presentation and I missed it. So Article 8 of the Artemis Accords cursorily references that scientific data will be shared, but it also says that the states are in charge of whether they even want to release the scientific data in the first place or not. So forget actual material benefit sharing, which is not mentioned in the slightest. Even scientific data seems to be completely dependent upon whether the state wants to share it or not. So even on that account, I think it kind of fails in benefit sharing or as a global commons. On how developing countries can function. So again, I don't think it's realistically going to happen. So I think the Moon Agreement was the right step in that direction, because they did actually say that there should be material benefit sharing in addition to scientific benefit sharing. And then 17 countries signed it and it tanked. So I'm not entirely sure that there's a reasonable way in which, like, I think inevitably the way it's been set up right now is it's like whoever gets there first gets the benefits, which I do think is illegal, but I'm not sure that there's any way in which we can stop that. And again, I'm not an international lawyer, so I don't really know how we would change this. I have no idea. I would say that until we can figure something out, I do think private property claims need to be banned in space until we have a comprehensive framework. I think that currently, in the current way that they're emphasized anyways, they're illegal in outer space law. And so I don't see them as something that we should allow. Again, I don't know who would enforce that. So if SpaceX goes and extracts some resources tomorrow, I'm not sure anyone is going to say anything to Musk. So I don't know. Yeah, and I'll leave it to you guys. Maybe you know better. I'm not an international lawyer. I don't know.
Kushak, because you all the time you mention that you're not an international lawyer, and I'm also not a constitutional lawyer. But now I will challenge you because I hear what you say and the discussion we're having. What if now on the constitutional plane, I bring a case before the Constitutional Court of India against India due to the Indian Constitution, based on the Indian Constitution and the quality and justice that the Indian Constitution embraces, against the international acts of India in the moon? Do you think that such constitutional case would thrive in India? Like, for example, in South Africa regarding the right to housing that we had some decades ago. So what do you think? The constitutional law cases can play a role on this, or the Constitution doesn't have any power vis-a-vis international law?
Thank you. For reference, I'm currently clerking at the Constitutional Court of South Africa. I'm rather well
even better.
Rather well placed to answer this. So India is not a monist country, it's a dualist country. It has to adopt any international law standard for you to enforce it. It's not adopted the Moon Agreement, it's only adopted the Outer Space Treaty. And I don't think India's violated it just yet. I think all it's done is explored, which is allowed under outer space law. So I'm not sure that you could bring a constitutional case against the state. South Africa is a bit funny because it's sort of halfway in the middle of monism and dualism. It needs to be adopted, but at the same time, the Constitutional Court does have the power to enforce international treaties. And weirdly enough, they also allow you to sue foreign states. They don't really care about the whole sovereign principle. So I suppose you could try and bring a case in. So South Africa doesn't have a space program, so to speak of. But you could bring a case against the US and South Africa if something like this happened. I'm not sure what the enforcement would be.
Because you said it's not only the US, you mentioned also Japan and other states that also have the same. So, for example, not to take the US paradigm, but take Japan or another state that participates in the programs. So the question is constitutional in a broader sense.
No, I think it's a valid method to go under. Like when you think that there's no international regulatory authorities, you can turn to national regulatory authorities. I don't know too much about Japanese or Luxembourg constitutionalism, in fairness, but I do think that I see the value in that premise, but I don't know how. The constitutional courts generally defer to executive action when it comes to foreign policy, especially like the US. So how much they would be willing to step on those toes, I'm not entirely sure. I definitely think it's not an option in the US. It's an option in India for sure if India does actually extract private resources. I think we could reasonably go to the Indian Constitutional Court. But it's an option. It just depends on what constitutional framework you're operating under, both politically and normatively. And I don't know enough about the Japanese, UAE, or Luxembourg's to make a comment on it.
Also, Alberto has something to say. Just to be fair also with Alberto's presentations and Fiona's, this will be the last question regarding Cusack's paper, and also from you, from the audience, if you want to voice now, either in the chat room or raise your hands and ask something about Cusack's presentations. Otherwise, we'll proceed to discuss Fiona's presentations. So, Alberto, yes, the last question or comment about Cusack's presentation.
Yeah, sorry, it's I raised my hand because he spoke about Luxembourg, and as a Belgian jurist, it's for me it's relatively similar to what I'm used to work with, and yeah, it's a monist system, and there's a very interesting thing that happened just before they made the law on outer space, that they sent it to the Council of State to check its compatibility with the Constitution. And the text of the law said that, this thing had to be done in accordance with international law. And the Council of State raised the point saying, well, international law actually has the common heritage of humankind. And this might not be in accordance with international law, actually. And what happened is that the legislator simply deleted in accordance with international law from the law and enacted it, very simply. I'm not sure what this says. Yeah, exactly. I'm not sure what this says, but it happened.
So very interesting. Thanks, Alberto, for this point, because we see sometimes the practicalities of law and how it's important for us academics to be in touch also not only with theory but also with practice. As I said, I don't see any other questions regarding Cusack's paper from the audience, so we go to discuss Fiona's paper. If Alberto and Cusack, you have any comments, questions regarding Fiona's presentation? I have a first question. Maybe I can still open the panel. Fiona, thanks very much. Actually, you brought, because I specialize in the laws of war also, you brought me memories about the Tallinn manual and cyber warfare, etc. And the question is, and you mentioned space pirates. To tell you the truth, from the title of your presentation, I would think you would focus on universal jurisdiction, meaning on international criminal law, and trying to make the mutatis mutandis argument regarding trying violators of the outer space before national courts. So I didn't hear, I think, so much about this. You touched a bit, but my question would be, what do you think, how international criminal law and the crime of piracy can become now a crime of, if it can become a crime of space piracy? So this is my question.
Sorry, could you repeat the question, please?
My question is, we have the crime of piracy in international criminal law and universal jurisdiction about it. I can try a pirate who actually boards on a ship in the Horn of Africa. But when you speak about space pirates, do you have in mind maybe trying through universal jurisdiction in domestic courts, also non-state entities who actually violate the premises of the outer space?
Yes, I mean, for my PhD, I'm currently looking at enforcement in universal jurisdiction and international criminal law. Piracy, I was definitely considering it through the universal jurisdiction, national courts, and just really impact. I mean, one of the big gridlocks at the moment is how, what action can a state take if there is a threat in space, because the current system doesn't allow for example, if you've got a loose cannon satellite that is under control of in a very serious circumstance, can anyone act? At the moment, it exists that you've either got peaceful purposes or, is it a threat of war? So it was about trying to find a balance between, we don't want to be put in the position that every act has to be one or the other. Piracy, I felt, allowed us to take a more diplomatic approach to minor events, which might allow states to step in if necessary, if there's a cyber attack on a satellite, to offer assistance perhaps to bring it back under control. So that was the purpose behind it. And yes, I'm using universal jurisdiction.
So you say that in essence, through universal jurisdiction, I can try this space pirate in all the national courts around the globe.
Absolutely, why not?
Yeah,
Yeah.
I will tell you why not. Because of
Okay.
the same reason that we have policy, maybe political hurdles when we come to universal jurisdiction in international criminal law. So my question is, have you considered, or what's your comment regarding any potential obstacles that this idea of implying universal jurisdiction in space pirates may encounter? Because, for example, politicization, because of diplomatic relations, because of, as Kuzak said before, one country stepping on the boundaries of the other country. How do we actually relate to all these considerations through the piracy issue? Yeah.
I mean, at the current position, I was looking at the possibility, whether that was an option. Obviously, there are many, many issues to discuss at the moment. I mean, the UK does recognise piracy law. We have that in our legislative system. I'm well aware that other countries don't. So it would not be necessarily a possibility for them. And certainly, clearly, laws would need to be passed to facilitate that. I mean, countries that don't even have UNCLOS within their system, therefore can't apply piracy. So
no, piracy is international crime, irrespective of whether a country has ratified or not UNCLOS.
Yeah.
So just to make this differentiation between international criminal law, universal jurisdiction, and UNCLOS and the law of the sea. But Fiona, I will ask also a second question. Of course, again, everybody is free to Kushager and Alberto and the rest of the audience if you want to ask something. Kushager, I think you want to ask something, or your hand was just...
Yeah.
Yes.
No, I can. Yeah. There was a distinction you made, sorry, Fina, in the middle of your presentation where you said that an armed vessel is inherently considered to be a pirate or a pirate vessel. And then you said something which I kind of got lost in, where because most spacecrafts are dual purpose vessels, they kind of inherently run that risk, irrespective of whether they're armed in the traditional sense or not, which I think sort of opens up a really broad line of inquiry. So I'm kind of curious, like, how would that translate into, just space vessels, which are dual purpose mostly?
I think the dual purpose aspect of a lot of spacecraft is a major concern in the sort of space law arena, and there's a great deal of discussion that a lot of satellites put into space have the capacity, if people so choose, to become offensive quite quickly. So, for example, like the space tug, it's a brilliant idea. It's there to clear up debris, but it also has the capacity to pull around other people's spaceships. And given the sort of geopolitical tensions at the moment, the threat of somebody in space being able to drag somebody else's satellite is causing concerns. The point, yes, I think there needs to be greater clarity as to when a satellite is civilian, when it's military, and that there needs to be more clarity on that. And prima facie, if it's not authorized, which is the obvious concern, then it would be a pirate vessel.
Thank you very much, Fiona. Just to say that we saw also the sign that in 30 minutes and less now, the panel is going to close. To thank everybody for the participation and the audience for being here. And indeed, with wonderful presentations, wonderful papers, and looking to see each other now in the main room as we go back now by the organizers, by the BIICL handlers of the electronic system. So indeed, nice to be here with you and to listen to these presentations.
Thank you.
Thank you very much.
So we wait now to be taken back to the main room. As we're waiting, just to say that indeed it was interesting that we saw, and we're going to have to go back now, so see each other in the main room.
Ok, va bene.
Hi again, everyone. I hope you all enjoyed that last session. We're now coming to the end of today's workshop, but before I wrap things up, I would like to briefly hand over to my co-convener, Saeed Bagheri of SLS, to make some closing remarks. Thanks, Saeed.
Can you hear me now?
Yeah, thank you.
Well, thanks, Jojib. Well, to be honest, I was asked to give some closing remarks, but unfortunately, I missed the last part. The last part of this event, which is a shame. But unfortunately, I make it out because I was teaching all day. Anyway, I hope everyone joined this event today. When I was reading the abstracts, I was really impressed with topics, and at least in the last event, the last panel 7 that I was chairing, I really enjoyed. But we didn't have time. I still have many questions to direct to our speakers. Again, I really, to be honest, I don't have many points or different things to add to excellent contributions that you have today. But I would like to highlight what we mentioned previously in our call for this event, that international law still remains a state-centric set of rules that where the primary subjects of international law still are state members of the UN. But from my perspective, I think what remains in question is that other individuals and non-state actors are playing a significant role in the evolution of international law, or perhaps its implementation and, of course, its enforcement. We just need to remember that they are always shadowed by states as the primary subjects of international law. But I do believe that it would be convenient just to observe that international law is not or should not be, just should not have the states as the primary subjects because of the undeniable role of non-state actors in the contemporary international law. That are the only things that I can say. So we need to consider, even when we're teaching to international law students, I'm just trying to mention that we have different categories of non-state actors, but we need to consider them as part of this international legal system. And the fact that there is a space to think and reflect on some critical legal questions, such as why we have states, or perhaps the harm posed by all states against public order that they provide. Or perhaps the impact and the pressures of developed countries against developing countries, and whether this is a question that I'm trying to ask to all people. Specifically our students and also perhaps our panelists today, that whether there is an alternative way to construct international legal system. Well, this is significantly important, and of course, in the meantime, this becomes more prominent when it comes to non-international conflict. Because, to be honest, I'm international lawyer. I'm doing research on international and non-international armed conflict, specifically non-state armed groups. So this is also important and relevant to the important role of non-state actors in terms of the formation of international law, even in treaty or customary international law. And as you know, already it is now widely accepted by the international community that international humanitarian law is applicable to all parties in non-international conflict. But unfortunately, as we can see, the majority of non-state armed groups around the world, they do ignore the applicable the rules of international law, purely arguing that they have never been part of those international regulations. They have never been engaged in the formation of that specific rules of international law. Again, to me, this is a question of whether and to what extent territorial states identify the legal status and the legal personality of non-state armed groups, just for the sake of individual protection during non-international conflicts. And of course, we know that there are continuing arguments on the impacts of the identification of the legal status of such armed groups on the sovereignty of states. There are many cases, for example, cases from Turkey or Colombia, that they have tried to justify the unlawful killings just because they do not recognize the legal status and legal personality of non-state armed groups who just party to a non-international conflict. But anyway, I hope these are sort of some questions that that we just need to address. Again, it is pretty clear to me, at least, that negotiation and and building trust between states and non-state actors, specifically during conflict, at some point, they require the territorial states to consider the legal personality of non-state armed groups, just in order to stop the cycle of violence. This is what I hope that at least we can see in practice at some point. Well, I hope these sort of academic events and discussions will help us to think critically, particularly in order to contribute to the existing legal discussion in relation to the legal personality of non-state actors, and how they can contribute to the formation of international law, in particular customary international law, and of course new international legal standards, which would enable them in some ways to contribute and to subscribe to international accountability frameworks. Again, thank you all for your contributions, and hope that you enjoy the event, and I wish you a great week ahead.
Thanks, Saeed. Before we conclude for today, I'd just like to take a moment to thank everyone who contributed to making this year's workshop happen. This includes not only my co-conveners, Jean-Pierre, Solon and Saeed, but also the co-chairs, Aditi and John, and also several members of BIICL's events and marketing teams, in particular Liam, Bradley and Carmel. These workshops are really important collaboration between BIICL and SLS, and I'm incredibly grateful for the hard work and time that all of you put in to make sure today's event came together and went as smoothly as it did. And last but obviously not least, I would like to thank each of the panelists for their fantastic presentations, and everyone who attended and contributed to the enriching and interesting discussions that we had over the course of today. I hope you all enjoyed this year's workshop and took away from it as much as I did. So thank you all again for your attendance and participation, and we look forward to seeing you again at next year's workshop. Thank you.
Thanks, everyone.
Thank you very much indeed.
Thank you. Thank you. Goodbye.
Thank you.